How can I improve my chances of winning on appeal? If you're watching this video, you're probably an attorney or a litigant who is considering either filing an appeal or responding to an appeal filed by someone else. And you probably want to win. But the appellate process is a tangled web filled with traps for the unwary. There are lots of rules, but some are unenforced. Others are disobeyed only at one's peril. And there are unwritten rules that govern the process even more effectively than any written rule. So to begin, I answered the question with a simple answer. Don't make any mistakes. Now that was simple, wasn't it? But all mistakes are not created equal. In this video series, I offer my list of top 10 appellate mistakes. Okay, unlike the 10 Commandments, there really aren't any top 10 mistakes. I've rounded them out to give a certain literary flair. In this first segment, I will address a serious procedural error that regularly traps attorneys who don't routinely venture into the appellate realm. This one comes up all the time, the motion for reconsideration. Because here in Pennsylvania, filing a motion for reconsideration doesn't toll the time for filing a notice of appeal. In Pennsylvania, unlike other jurisdictions, say New Jersey, filing a motion for reconsideration does nothing. It doesn't toll the time for the filing of a notice of appeal, and yet over the years I've seen even prominent attorneys who should know better file motions for reconsideration and just assume that doing so relieves them of the duty of filing a notice of appeal within 30 days of the entry of an adverse order. It doesn't. Pennsylvania law is clear that one must file a notice of appeal within 30 days of the order from which one seeks to appeal. And yet several times a year, I receive phone calls from attorneys whose notices of appeal were stricken, begging me to tell them that there's some way around this. There isn't, at least not in Pennsylvania. Now, if these attorneys were in New Jersey, they'd be sitting pretty. The New Jersey appellate rules contain a wonderful provision. Under this rule, the timely filing of a motion for reconsideration of an order tolls the time for the filing of an appeal. In the federal system, there is no such animal as a motion for reconsideration. Federal Rule of Appellate Procedure 4 contains handy subsection 6, which provides that the filing of a motion for relief under Rule 60 tolls the time for the filing of a notice of appeal. And the case law generally holds that a motion for reconsideration is such a motion. Therefore, in the federal courts, as in New Jersey, the filing of a timely notice for reconsideration tolls the time for the filing of a notice of appeal. Not here in Pennsylvania, however. So how do you avoid this trap? Simple. Keep your eye on the clock and file a notice of appeal within 30 days. And if you are even thinking about filing an appeal, consult with an experienced appellate lawyer. If you don't, you may find that you have forfeited your right to seek appellate review.